Hi, I'm Nancy Cavey, a National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Today we're going to talk about disability and estate planning with my special guest, Attorney Autumn Hancock. Prior to us starting, I was talking about our topics with her, and I've learned a ton of information that I'm really anxious to share with you today. Now, among the things that I've learned so far in my discussions with her is that a disabled person needs to have perhaps a will and estate plan that might be different than the person who is caring for them. So I'm going to ask Autumn to expand about that. We're going to talk about why you might need a will or change your will. And we're going to cover lots of other topics that she's anxious to share with us. So welcome, Autumn. Before we get started, though, I have to be a lawyer. I have to tell everyone on this podcast that we're both lawyers and we're not giving you legal advice, but we're just talking generally about disability and wills and estate planning. So now that we've said that, let's get going. First, Autumn, can you tell us about yourself and how you came to be a wills and estate attorney?
Sure, Nancy. Thanks for having me. I'm originally from Maryland and I grew up in Sarasota with my parents. My dad owns Hancock Financial Services, which does a lot of elder planning for senior citizens in his community in Sarasota. So I spent a lot of time in my younger years around that kind of, looking at annuities, looking at life insurance. And I ended up in law school at Stetson. So I fell in love with St. Pete naturally because it's awesome. So I stayed here. And I started working in divorce litigation and real estate litigation. And I came across a company, or I guess a charity that was doing free estate planning for first responders called Wills for Heroes. So I started researching. That really spoke to me. I'm passionate about that issue. My husband's a firefighter of 20 years with no estate plan. So as are many of his friends. So I started getting more and more involved with Wills for Heroes and volunteering. Then I started planning their programs for the area and doing a lot of estate planning for first responders and learning more and more about it. So I left my law firm that I was with at the time and started my own practice a couple of years later. And here we are. The rest is history.
Wow. Well, thank you for your work with first responders.
Of course.
Now, most people think about estate planning and wills for old folks. And of course, none of us are old. But people who are disabled and unable to work don't necessarily think about why they need estate planning or a will. So let's first talk about what is estate planning and what is a will?
So an estate plan is the process of deciding how you want property distributed throughout your life and once you have passed or after your death, and developing documents to make sure that your decisions are carried out throughout the course of your life and after your life. A will is a tool that's essentially like part of your tool belt in an estate plan. So a will is a written legal document that's signed by an individual, and each state has its own execution rules about who needs to be there, how many witnesses, those kind of things. But it needs to be formally executed. And that is a document that says what happens to your property and to your person after you die. So the will's only about what happens after death. The rest of the estate plan is what can happen now and throughout the course of the rest of your life.
So I like that concept of a toolbox. So what are the elements of a toolbox, if you will, for someone who is disabled and unable to work in terms of their estate planning? And then let's talk about perhaps the caregiver who might be giving them care and what should be in their estate planning. So we've got two distinct individuals here that we want to talk about.
Right.
So
Sure.
Tell us what we need to know.
Sure. So for family members with loved ones with disabilities, an estate plan usually will mean, how can I make sure that my loved one is taken care of when I'm gone? And if I'm caring for that person and providing any kind of financial assistance to them, how can I make sure that that financial assistance doesn't negate their ability to receive other benefits that they might be eligible for or might become eligible for later? And for individuals with a disability, estate plan means, how can I control my property while I'm alive to make sure I stay eligible for my benefits, but also how can I give what I have to who I want when I die? So when we're talking about, there's so many different ways, and it's very individualized that someone can accomplish these things. So there's things called an ABLE account, for example, where you can accumulate more than the $2,000 that you're otherwise usually allowed to have and continue to receive benefits when you're disabled. But you put into a specific type of account that's managed in a very specific way that allows you to use that to supplement the benefits that you might receive. There's special needs trusts, and those can be set up by the disabled individual or by someone who's caring for them. For example, if you have a disabled adult child and you want to put money that you want to give to them, let's say in my will, I would want to give $50,000 to my disabled adult child, but I don't want that $50,000 to mean that she loses her Section 8 housing and her Medicaid and her maybe Medicare too, maybe her Social Security income. All of that stuff could go away because of that one gift. And even as an attorney, and this is getting complicated, but even as an attorney, if I'm to be able to reverse that, so let's say someone does that and doesn't properly plan. So, I die, I give all my nieces and nephews $50,000. My one niece is disabled. Now she, because of that gift, loses her eligibility for a lot of benefits. If they come in my office, that family, I might be able to reverse that. I might be able to make it go backwards. But even then, you're talking about potentially she's back on a waiting list for a long, long time to try to get back into the housing program or the benefits that she's receiving. So it's very important for everyone in the disability community, both the people that are disabled and their caregivers or people who are providing support to them, to really look at every angle when you're planning your estate to make sure that you're not doing anything that creates more harm than good.
So I want to clarify something because people might be a little confused about Social Security benefits, for example. There are two types of Social Security disability benefits. One is Social Security disability benefits, which is based on your earnings and your records, or there is Social Security supplemental income, SSI. That is asset-based. So if you're collecting SSDI, a distribution by a family member isn't going to impact your SSDI benefits. But on the other hand, if you're collecting SSI benefits, which is an asset test, then a gift from a family member or friends or relatives can impact your eligibility for your SSI benefits.
Right. When you're thinking about eligibility requirements when it comes to estate planning, there's usually what we categorize as three major governmental sources of assistance to persons with disabilities. And so inheritance will impact all three of them. So the first one would be something like Social Security disability income or pension, Medicare, benefits that are
not SSDI, SSI. Okay.
Well, I'm saying Social Security disability is available regardless of assets or unearned income. So that's the first category. Pension, Medicare, SDI, those ones you can get regardless of your income or your assets. Then there's the second category, which is they're eligible only if their income and assets remain below a certain level, which typically we would say $2,000, which is traditional, but not always exactly the case depending on your situation. But that one would include SSI, so supplemental security income, Medicaid, medical assistance for Medicaid, food stamps, general assistance, like Section 8, things like that. And then there's a third category, which is the eligible persons regardless of assets or income, but it might carry a cost with it, like vocational rehabilitation services, things like that. So we categorize all three of those when we create an estate plan as three different things, and we want to look at all three of them and how they impact the whole plan.
So is there any other special reasons or needs why someone who's unable to work should have a will or do the estate planning? And if so, at what point in time should they be considering having a will or doing estate planning?
So estate planning in general, any person who's reckoning with a disability, particularly a progressive condition, whether it be intellectual, physical, or both, needs to ensure that they have not just their will, but their healthcare advance directives and their powers of attorney in place as soon as possible. And those are the three basic things, I guess I should back up, three basic things that everyone should have in their estate plan. So when I do it for my first responders, even if it's the most basic, it includes a healthcare advance directive, a power of attorney, and a will. So those three things is what I think everyone should have. Like your 18-year-old neighbor should have that.
So could you break those three things down for us?
Yes. So a will, like we talked about, is the document that will talk about what happens to your stuff and to you when you pass away. A healthcare advance directive is, a lot of people call it a living will. So some attorneys will do two documents. One's going to be called a healthcare surrogate designation, and one's called a living will. And the healthcare advance directive is both of those things combined. So you can put it together, you could do it separate. So the healthcare surrogate nomination is going to say who's going to make decisions about your healthcare if you're unable to, for any reason. It can be that you're unconscious, you're in a coma. It could be that you have some kind of intellectual or cognitive disability that creates a situation where you can't make those kind of reasoning decisions. And when a doctor says, hey, look, this person's unconscious, we need to cut off one of their legs, we need permission to do so, who are they going to call to make that decision? So that's your healthcare surrogate.
Now, that's also important, isn't it, if someone has a progressive disease as opposed to these acute or traumatic events?
Absolutely. And a progressive disease, it matters so much because what you don't want is someone to be able to petition for guardianship over you because you don't have these things in place. So as things progress, you might be in a situation where your sister or your mom or someone else shows up and says, we're going to have to petition to become their guardian because there's no document that legally gives me the right to make these decisions. And now this person's disease has progressed to the extent that they can't create that document now, right? So you want to do it as soon as you can so you don't run into a situation where you can't. And you can edit it as long as you're mentally or intellectually, cognitively able to, but you want to make sure something's in place because petitioning for guardianship is expensive. It's very expensive for your family, and the money has to come from somewhere, and the court can make it come from you. But it also takes away some rights that you might not need to be, that you might need to be divested of. Go ahead.
No, go ahead.
Okay, so the next thing is a living will, and the living will is part of the Healthcare Advance Directive. That document tells what you want to happen in certain circumstances if you are not able to make the decision. So do I want life support? Do I want food and water through IV for as long as I'm in a vegetative state? And it usually categorizes into three different categories. So we talk about a terminal condition, an end stage condition, and a persistent vegetative state, which are three different things, which your planning team can explain to you in detail. But a lot of times are confused. So a lot of times people think a terminal condition is the same as a persistent vegetative state, and that's not the case. So you want to really think about, under each of those different circumstances, do you want life support? Do you want to be kept alive by artificial means if you cannot breathe, but your brain is alive? Like those different situations. So that's what a living will is. And you can put all of those things into the same document if you choose, which is called a Healthcare Advance Directive. Go ahead. The other document that I mentioned is the power of attorney. The power of attorney can give someone the ability to make health decisions, but usually it deals with financial decisions.
So how does disability impact a life insurance policy, and do any of these documents protect, for example, you if you were to become disabled and unable to manage your affairs from any of your relatives changing the beneficiary of the life insurance policy?
Right. So if you have a power of attorney, the power of attorney has the ability to change your life insurance beneficiaries if that is one of the powers that's given to them through the power of attorney document. So the documents, for what I like to tell people is, if you see a power of attorney that's less than 6 pages long, it's probably not detailed enough. So you want to enumerate every specific power that the person is allowed to do. So can they mortgage your real estate? Can they go empty out your bank account? What things can they do and what things can't they do? So if one of the things is they're allowed to manage your life insurance policy, then they can do that. But every other random relative that you have doesn't have the ability to do that. So you just want to be careful, and you want to make sure that you put the power of attorney is effective immediately. So it's a little different than the healthcare advance directives because the person that you appoint as your healthcare advance directives can't do stuff against your will, right? So if I'm sitting up in the hospital bed, I'm like, no, sir, I don't want that. And they're like, no, yes, look at this paper, I can do it. That's not how that works. But a power of attorney becomes effective right away. So as soon as you give it to that person, they can go to the bank and empty your bank account, and the bank's not obligated to call you and say, hey, do you want them to do this? So you don't have to be under any kind of disability for the power of attorney to become effective.
Whoa.
So it's scary. You gotta be real careful with those ones.
Well, that is. So that's a lot of great information that we've talked about. Let's take a break, and we're going to come back, and I've got some more questions to ask. All right?
Sure.